The death of a loved one is something that is tragic, and we cannot escape from that. As advisors, we often meet with clients who have just experienced loss, and it's really hard walking them through that season of life. We want to enter that pain together with them. And one of the challenging things is when you inherit an IRA, then what are you to do with it? So today, we want to walk through some of the complexity of what happens once you've inherited an IRA.
There are certain elements of financial planning that a client will typically only experience once. And inheriting an IRA is one of those. Many clients, they'll never experience inheriting an IRA, but others, they may walk through that process once. And there's so much complexity around it. We'll dive into that today. And some of that has to do with legislative change. Some of that has to do with just the nature of the fact that when the federal government came up with the laws around retirement accounts, they weren't gearing these towards multi-generational situations. Yeah. So we'll talk through all of the different pieces here that we think are the core elements, but there's a level of complexity. Obviously, there's a level of grief for clients as they move through this, but almost nobody sits down with us and says, okay, I think I've got my arms around what to do with an inherited IRA and what are the ground rules. Yeah. So Austin, can you talk us through where are we at right now? Where have we been historically? What's the framework for how we should think about these inherited IRAs?
Yeah, absolutely. And like you were saying, there is complexity. There's tremendous amounts of complexity. We've got before Secure Act of 2019 and after Secure Act. And then the IRS continues to punt on some of the rules even after the Secure Act was passed. And so just as you hear what we talk about today, as you ingest this, realize that there is a tremendous amount of complexity to these inherited IRAs. So don't take anything that we say as tax-related advice to your specific situation. You really should work with a financial advisor on these things. And so before the Secure Act passed, it was relatively straightforward. Now, I say relatively with a grain of salt because there's nothing that's straightforward about it, but it's relatively straightforward. You inherit an IRA. If it's a spouse and it's before their required minimum distributions have begun, then you just roll that over into your IRA, and then you can start taking out distributions based on your lifetime expectancy table from the IRS at your RMD date. For non-spousal beneficiaries, once the decedent passes and you inherit that, then you're gonna have to start taking it stretch over your lifetime. So let's say a father passes away, passes it down to a son, the son is gonna start having to take distributions over their life expectancy table. It's the stretch rule. That was done away with when the Secure Act passed. And so what happened with the Secure Act, if you are a spousal beneficiary, it's a very similar situation. You roll it into yours and then you start working off your table. Again, there's complexity here, but by and large, that's the case. Again, with a non-spouse though, that's where the complexity really starts to dive in. And oftentimes this is where the most confusion comes. So what the IRS said, or what the Secure Act says, is from the date of passing, if you've inherited an IRA anytime after January 1st of 2020, on or after, then you have 10 years to take out a full distribution of the account. Now, there wasn't a whole lot of guidance given beside that. What was come to find out later was the expectation was that you would take a distribution every single year, and then it has to all be distributed by that 10th year. And again, if you remember, IRA distributions are taxed at your ordinary income level. And so that, again, brings up a lot of complexity for these beneficiaries. And so what we're looking at is there are different levels of where you have to take that distribution. And so these annual distributions that were expected, again, are based on your lifetime expectancy. So it's not just a 10th of the account needs to come out every year. You can take out more if you wanted to. You can take out less, but you were supposed to take out at a minimum what was required of you based on your life expectancy. And so you have to look up the IRS tables. If you're 40 years old, then it's going to be less than if you are 60 years old. It's going to be less than if you were 80 years old. But there's going to be an amount that is expected to be taken. Now, here's the caveat though, is that every year, 2021, 2022, 2023, and now in 2024, the IRS has said they'd waive the penalty if you don't make that distribution. So it really makes this complicated because you've got this Secure Act that says this is what you have to do, but then it's not being enforced. Right. And so it adds even a higher level of complexity and confusion to this.
So it's not being enforced on an annual basis, that required minimum distribution, but the IRS still expects that within 10 years, if you had a loved one pass away in 2020 or 2021, the expectation is still that within 10 years, you've got to take a full distribution. They're just being more lenient on the year-to-year factor-based distributions.
Yeah.
And to give you just a little bit of a sense, if you're 30 years old and you inherit an IRA, roughly speaking, the government is going to say, well, you probably have about 50 years life expectancy. You've got to take out about 2% per year. So not a tremendous amount, but that would add up over time. And then within 10 years, again, you've got to take out that full distribution.
Yeah. And there are some exceptions to this. So there's 5 classes of eligible designated beneficiaries that can receive special treatment. So one is the spouse. So we've kind of already touched on that briefly. Another is a minor child. So if a minor child, let's say they inherit an IRA from a grandparent and they're 8 years old, or let's say they're 6 years old, they can stretch it up until the time that they're 18. But then once they've reached the age of majority, then they have to take that full distribution. So they've got a little bit more space to take it out. But the 10-year clock starts again once you reach that age of majority.
So for them, they've got from age 6 to age 18, they've got to take this small amount annually. Then the 10-year clock starts at 18, and they've got another 10 years where they got to take out a little bit, but at age 28, it's got to be fully distributed.
Yeah, and so the next piece is beneficiaries with certain disabilities or chronic illness. They may not have to actually distribute it by the 10-year clock. And then the last one is a non-spouse who is less than 10 years younger than the decedent. So let's say the decedent is age 90, and then they pass it off to a brother or a sister who's 85. So there's less than a 10-year time frame there. The IRS is going to say, yeah, you can go ahead and stretch it out for the remainder of your life. So again, there's a whole lot of complexity with these where you really need to work with a professional to figure out what is required of you.
So we have that level of complexity. What are ways that we kind of think about how to use this strategically with respect to tax planning, with respect to the needs of a financial plan, and someone who's looking at it? How do we make sense of these pieces together?
Yeah, so what we'll do is we'll walk through 3 different scenarios that may help kind of clarify. And again, these are hypothetical scenarios. So again, work with someone to figure out your specific situation, but we'll just kind of talk through 3 assumptions. So the base assumption for each of these scenarios is we've got a patriarch who passed away in 2023, had $1 million in a traditional IRA. And he gives each of his beneficiaries $250,000. And so the beneficiaries are expected that they will start their distributions in 2024. Because the patriarch had taken his distribution for 2023, then the first distribution for the beneficiary begins in 2024. So that means they have to all liquidate their IRA, their inherited IRA, no later than December 31st of 2033. So it's 10 years from the year end of the beneficiary or the patriarch's passing.
Now, if the patriarch is, one quick note here is if the patriarch has already attained that required minimum distribution age, they've got to take that full RMD in the year of their passing.
Yes.
Correct?
Yes, they do. Yeah. So you can't skip that 2023 RMD for the decedent.
Right.
So let's take scenario 1. We've got the patriarch Paul. His son Andrew has turned 70 and a half in January 2024, and he gives generously to charities. We say 70 and a half because that's that magical age for
Qualified charitable distributions.
Qualified charitable distributions. So Andrew this year must take around $14,000 in 2024 for his RMD. That's what he's expected to take. Again, the IRS has made that guidance, but that's the expectation. So we're going to make the plan based on the expectation that he has to take at least $14,000 out of that $250,000. So Andrew's Social Security provides for his regular living expenses. When he needs additional funds for vacations, home improvements, he typically takes those from his own retirement accounts. Over the last couple of years, Andrew has been giving charitably to a donor-advised fund, and now he's going to start utilizing qualified charitable distributions. Well, what we would see in this situation is if Andrew needs to take a distribution for living expenses, he's required to out of that inherited IRA. Mm-hmm. So if he needs an extra distribution for a car or for an emergency expense that comes up, this is probably the best lever to pull. Mm-hmm. But if he doesn't need those, then hey, let's encourage Andrew, give that qualified charitable distribution. He can give up to $100,000. So if he's looking at his long-term financial plan and knows that in a couple years, he's also going to have required minimum distributions from his own IRA. Okay, hey, maybe we accelerate that giving from this inherited IRA so that he never has to take out those full distributions and have a taxable distribution. So for him, in some ways, it's a fairly simple, straightforward decision. Hey, we need a distribution, go ahead and take the distribution. If not, let's push it to charity. So the second situation is we've got Paul's son, Bob, and daughter-in-law, Betty. They're both 65 years old. They've just retired. So they're a little bit younger, and Bob must withdraw about $11,000 a year. So again, Andrew is older. He's got to take more out. Bob's a little bit younger. He's got to take a little bit less out. They were both planning to take Social Security when Bob turned 70 and Betty turned 67. Before they passed, they were utilizing resources in their personal retirement accounts and non-qualified to cover their base expenses. They've got no other income streams, so they need some income to get them off those last couple years until they start taking Social Security. They need a gross distribution of about $70,000 a year before Betty's Social Security kicks in, and then they'll only need about $50,000 thereafter. In this situation, kind of depends on where non-qualified resources sit. What we would typically recommend for clients is you take the non-qualified resources first, then you take those qualified second. But you've got $11,000 that you're supposed to be taking in that distribution. And so we'd say, hey, let's look at and see, let's take that $11,000 out. If that covers it, and then you've got non-qualified resources to then fill that gap, then that's a good place to start.
Well, and really, we've got 10 years here, and so we need to look at this case by case. But it could be that we say, well, we're actually going to prioritize distributions with this inherited IRA over the next few years, hold the non-qualified resources because of their tax consequence, they don't have as much of a tax consequence when we have full Social Security coming in. So it could be that we do several years worth of inherited IRA, take a full distribution of these, and then now we've got non-qualified resources still in the mix that we can use for the first few years after Bob turns 70.
Yeah, so again, lots of levers that we can pull here. But again, it comes down to what is going to make the most sense for this client, their current and future tax situation. So the next situation that we've got here are Chris and Carla, Paul's niece, and she is 57 years old and they plan to retire in 5 years when they turn 62. So Carla's required distribution for this year is $8,400, but they're currently in a 24% tax bracket. They're both working and making good money. They're contributing the maximum amount they can to their retirement plans. But because they have to take a required distribution each year, that's going to add to their income that they have. And so where in some of these other cases with Bob and Betty, like you were saying, if they're in a low tax bracket because they have no other income, okay, we can push that distribution higher. Well, with Chris and Carla, we don't want to push that distribution a whole lot higher to liquidate the account faster because we're adding tax in a higher tax bracket right now. So we'd say, hey, for these next 5 years, maybe take just the required minimum distribution. And then once you get to that retirement age, hey, now let's start really accelerating those distributions from this account for those living and giving expenses that you have on a day-to-day basis so that you can continue pushing off and deferring Social Security until it's time for that maximum benefit to rise.
And Carla and Chris might be a couple that we even look at and say, okay, is the IRS going to enforce these on a year-to-year basis? Because if you don't have to take it and you'd be more than willing to take it in 5 years, maybe, you wait until the guidance, and if they don't offer guidance by the end of the year, you take it because that's what you're required to do. But if like in 2024, they give you guidance, by springtime, say, okay, well, I'm just not going to take it this year. And by the time I turn 62, I'm going to really need to take these funds out.
All right, so this last scenario, David and Denise, if you've been following my pattern here, I've got A, B, C, and D. So fourth scenario are D letter names because I am just that creative. So scenario D, David and Denise. This is Paul's granddaughter, and they're 30-year-old public school teachers. So they're really raking in the money right now. Their required minimum distribution, if the IRS says they have to take it again, is about $4,500. So just like you were saying, If you're early 30s, it's not going to be that punitive, about 2%. So their annual taxable earnings is about $90,000 combined. And they're squarely within that 12% current tax bracket. But they've got some student loans and they want to be able to buy a house.
Yeah.
And in the next few years, they're also looking to maybe take on assistant principal roles or higher level roles within the school system. And so the reality is when that happens, salaries are likely going to increase. And so for these guys, it may make sense to think about, okay, can we take higher levels of distribution right now, fill up that 12% tax bracket, especially as the tax brackets are set to go up to 15 and maybe even a little bit higher? What does it look like to take on some additional distributions while taxes are low? Let's get some funds into a down payment for a house. Let's go ahead and pay off that school debt. For them, because again, taxes are low, it could make sense to make some additional distributions now to really get that money into their hands and accelerate that in the meantime.
Austin, thanks for walking us through that ball of wax of complexity that we touched on, all of the different pieces there. If you have questions, don't hesitate to reach out to us. Again, do involve your financial advisor in planning when you have an inherited IRA in particular. Until next time, take care.
If you like these financial planning videos, please share it with a friend, and if you have questions, go to our website at SiriusRetirement.com. This content was provided by Retirement Planning Services. We are located in Knoxville, Tennessee. You can visit our website at SiriusRetirement.com. The information in this recording is intended for general educational and informational purposes only, and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents. Advisory services offered through Retirement Planning Services, LLC.